Hmm.
I guess, parents, who all did you hear from to say they were not going to be in attendance? I know Jim Glenn is still with his mother.
And then Commissioner Fuentes, Smith, Henry. I think that's it. So when I was counting this morning, we were right at that line.
Right.
Morning, Kylie.
Good morning.
You Kylie's.
Hey, Kylie. Good morning, commissioners.
Terrence, what about Rick? Did you say whether or not you heard?
Oh yeah,
from
he
Rick?
won't be here either. That's the other one. Thank you.
Okay. And how many folks do we require for a quorum?
Half plus one.
6. We need 6. Well,
I'm so short I can always be the half.
we we don't have enough folks present to, in fact, we don't have a quorum, which means we cannot take any official action. But if we can, in fact, go through and receive the reports, and we'll do that. So I guess the first thing up, I would ask Terrence, have we had any requests from the public for public participation?
We did not have any requests for public participation, and yeah, that's all.
Okay, so let's move on and do the executive director's report.
Sure. Good morning, everybody. I first wanted to thank those of you who are here for being a little bit flexible with we had the date change and then the possibility of moving the date back, and then from in-person to Zoom. So I appreciate the flexibility. And then for those of you that were able to make it this week to the Urban League event, that was something that I thought was really beneficial and very informative. I'm going to be reaching out to the presenters to thank them for coming and giving their time. And I also, if anyone wants it, I have a copy of their presentation that I can share out. It was, again, very informative. And I personally got a lot of ideas. I have a lot of notes on things that we can look to do in the future. And I'm going to be bugging Joe very soon about how we can work some parameters to get some of those things done. A couple small updates. The reason we are on Zoom anyway is our air conditioning and all of that that I made you all aware of. I have been stressing them about getting that fixed and have allowed people to remotely when needed, just because it's been way too hot to even think about coming up to the 14th floor, or if people want to use the 16th floor for in-office space. Some of the air works there as long as you leave some doors open. It's very strange, but they are measuring to fix them. The problem is there's supply chain issues. They haven't directly communicated to me how long they anticipate them waiting. They did tell the state that it would be done by July 5th, but in some subsequent conversations with Brandon, the people actually doing the work said that was almost impossible. So I'm working with the state on trying to get something addressed on that. I also reinitiated that conversation about a possible relocation. So many building issues and looking at any exemptions to the state required process to move. So I've been going back and forth with them on that. There's an impracticability standard of if there can't be something done in 30 days, they can waive some of the requirements. But the problem is the building is telling them that they will have these things fixed within 30 days. The workers are saying that it won't happen. And so the back and forth is a little difficult to navigate, but that's something that I'm working through just because I don't want people. One, I want to make sure, and we had this conversation a few months ago, I want to make sure that we are in a building that's safe for people, and that is hospitable to the team, because we don't want people coming into this building where it's hot or the elevators don't work and all that. So I'll let you all know if there are what shifts on that updates.
Terrence, as it relates to that, the building has had a history of problems, and you went months without elevator access to the building. Now there is, in fact, a cooling issue in terms of just having an environment that's conducive to working. Those in combination establish the basis for the state property, whatever the group is, can declare an emergency and deal with that. Have we requested that they declare an emergency and deal with it, or are we just playing with them?
So that was what I was asking about, was getting the emergency, so we could have things happen more quickly and able to move or do whatever. And so that's where the difficulty is. This building is telling them that they can get something fixed.
I understand what the building is telling them. The reality of it is, what is it in terms of, from the commission standpoint, saying to the state, to that the group within finance, in fact, the building is not habitable. It hasn't been habitable for years. It hasn't been clean. It doesn't operate. And once again, we have this problem. Have we documented this stuff in writing to them and made the request?
Yes, yes, but the way that they've done it is, I've told Real Properties all of those issues. They have the history of the elevators, the air, some of the things that we were requesting being fixed. And so part of their process, as they said to me, is they still have to verify with the building and the building's ownership before they can. That's where he gave me the 30-day. And I told them yesterday that wasn't accurate, and that we still wanted to have that request fulfilled to get something changed.
Part of the ability to get Real Properties moved is papering up the process and documenting to them. Conversations don't move those folks. And in fact, whoever the commissioner is over there now, we just need to in fact respond. So have all of our things been in writing or just oral conversations?
It's all been through emails and then the forms to fill out to get those things shifted.
Well, what I would suggest is, before the end of the day, that you write a letter. If need be, you can write it for me and I will sign it, going to Real Properties, outlining what the issues have been over the years and requesting that they declare an emergency. And I will, in fact, sign it and send it over there. And I'll also send it to the governor's office. Okay. We got to quit playing with these folks, because, that building has deteriorated over the years. And in fact, and so there's no real effort in terms of doing it. And I understand, we need to deal with Real Property, but Real Property has some reality that they have to deal with as well. And so I guess the expectation is, when this is over with, let's get on the phone and, or you or Brandon or whoever else, let's start the letter, start the process. And so we can get this addressed, because we can't function if we're going to have function in the environment that we have to work in now.
Right. And I'll do a letter after this meeting before my next one, and then get that going.
Just make certain this is today's priority.
I will. Other things I will circle back to. I didn't want to keep Kylie too long. So we have for the presentation for this month, I've asked Kylie Moss from the ACLU to talk to us a little bit about LGBTQ protections at work and in housing, and really how it relates to, I'll jump in briefly to talk about how it relates to our KCHR application, but really just thinking about, Pride Month and looking at some of the changes in the law and some of the things that we still need to work on. I asked Kylie and she graciously accepted to come and speak with you all about some of these things. And so I'm going to bring this up, but if you want to introduce yourself, Kylie, while I'm getting this PowerPoint started, I will do that.
Thank you so much, Terrence. I'm really excited to be here, folks. My name is Kylie Moss. I am a legal fellow at the ACLU of Kentucky. I moved to Kentucky back in September 2021, so it's almost been a year. I'm originally from Virginia, but I am licensed. I went to law school at William & Mary, and moved here from Silver Spring, Maryland, so right outside DC. So I'm a DMV girl. And so I'm licensed both in Maryland to practice law as well as in Kentucky. And so it's so exciting to be before the commission. And I just want to say I'm like really excited to meet you all. And thank you so much for your really important work. When I grow up, I want to be just like y'all. I think you do amazing work. So I just want to say thanks in advance for your time and attention. And I also want to say that please feel free to interject or ask a question in the chat. I'm really bad at multitasking. So if someone has a question, someone kindly let me know. There are no dumb questions and there are no offensive questions. I definitely want to make sure that everyone walks away with at least a greater understanding of some of these concepts. And if I don't know something, I'm not in law school anymore, so I don't have to fake it. I can just say, hey, don't know the answer to that, but I'll find a way to get that answer to you if you have a question. And so without further ado, we're going to talk about LGBT protections at work and in housing. And thank you. All right. So the session objectives for today is first, understanding the distinction between sexual orientation, gender identity, and the various identities within the LGBT community. Then we're going to talk about the current state of law for LGBT protections in employment, and then Terrence is going to cover housing protections and how it applies through his work. And lastly, I'm going to submit and offer some ways for folks to try to be more inclusive and supportive of LGBT individuals. Not sure if folks have side businesses or you have family members who have businesses, but if Title VII applies to them, just really easy, applicable ways that we can create more inclusive workplaces and even housing if you have anyone who owns property or is a landlord. So on the overview, so we're going to talk about Title VII, and Terrence is also very knowledgeable about Title VII, which is the federal anti-discrimination statute that applies in employment context. So Terrence, please feel free to jump in or supplement anything I might have forgotten. We're going to talk a little bit about Kentucky fairness ordinances. We'll talk a little bit about Bostock and just some of the LGBT litigation that we've seen in the Supreme Court in the last few years or so. We'll talk about KCHR operations and then some final takeaways. All right, so before we get into the meat and potatoes of the presentation, it's really important that we talk about these different concepts in a way that's accessible and digestible, because a lot of it can be very confusing. And like my mom says, sometimes it seems like things are constantly changing. So I just want to make sure we all are kind of starting off on level ground here. So with gender identity is how a person in their mind sees themselves. So how they define their gender. Gender expression is the way one presents their gender through actions, how they dress, their demeanor. So how the world, it's like a lot to do with perception, how you show up in the world and how others might perceive you. Your sexual orientation, this is an easy one. This is who you're attracted to. And then lastly, assigned gender at birth. So when we're talking about my assigned gender at birth is female, that means that my physical sex characteristics that I was born with, a doctor said, okay, Kylie is a female, and that has to do with genitalia, hormones, chromosomes, body hair, voice pitch, etc. And so from this slide, what I want folks to walk away with, obviously, is understanding the difference between these four concepts. But when we talk about Title VII protections, we're focusing on sexual orientation, and we're talking about gender identity. And so if there's any question about how those two are different, I'm happy to go over them again. But just so that you know, and maybe Terrence can make this presentation available to folks afterwards, but these are the four concepts that we're parsing out. Next slide, please. All right, now terminology. So LGBTQ, a lot of letters, it's like a alphabet salad, whatever. These different letters describe different identities within the LGBT community. So for example, queer, I personally identify as a queer woman. And that just means to me that I'm not a heterosexual woman. I could be more specific and say I'm a bisexual woman, but queer is like the umbrella term for all these different identities. Queer, though, especially my mother's generation, I'm not going to say what year she was born in, but this word oftentimes was recognized as a slur. So kids in school were called queers. And so a lot of older people tend to bristle a little bit when they hear the word used so casually. But the word has since been reclaimed by younger generations to describe, again, it's that umbrella term for all the identities under the LGBT umbrella and community. And so you will hear older people kind of like maybe older lesbian or older gay people, they may not use this word to describe themselves, but some in fact do. Transgender, it's a term used to describe people who do not identify with the gender they were assigned at birth. So the doctor, when they were born, made a sex assignment and said, you are a female. But I decide later in life, like I don't feel like a female in my body. I don't see myself as a woman. I see myself cognitively as something entirely different. And so my gender presentation is going to start looking different. And so that's what transgender means. Trans, the prefix means different, whereas cis means the same. So I'm a cisgender woman. My sex assignment matches how I see myself. So that distinction is important. But going back to transgender, there's a lot of people that are included in transgender identity. Trans people, gender queer people, gender nonconforming people, gender fluid people, and non-binary folks. So those are a lot of different terms, and for purposes of this presentation and to respect everyone's time, I won't get into the nitty-gritty of each identity, but just so that you know, transgender is an umbrella in and of itself, and there's different identities that fall underneath it. Some outdated and offensive words would include transsexual, which you will hear a lot of in old TV, or you'll see in old court pleadings, not the correct term anymore. And transgendered, ED, that, it's just not a correct term. So if you want to sound like you know what you're talking about, you want to not use these terms. And then lastly, you have cisgender folks, and that's a term used to describe people who identify with the gender they were assigned at birth. Next slide. Okay, so Terrence, before I get into Title VII, do you want to jump in here, or do you want me to do this slide first?
You can go ahead and do this slide, and then I'll jump in on how it ropes into what we're doing.
Okay. Okay, so Title VII, I know many of you have heard of, obviously, but to, again, take all the legalese and the mumbo jumbo out of it. It's a federal law. It's part of the Civil Rights Act of 1964, and it prohibits discrimination on the basis of protected characteristics. And those characteristics include race, color, religion, sex, and national origin. This law applies to employers with 15 or more employees, and there are a few exceptions. For example, like a religious organization would be an exception. This law was created to ensure equal opportunity in America's workplaces and to remove historical barriers that have operated in a way to favor certain groups and exclude others, like Black people and women, for example. Congress has also passed laws to prohibit discrimination based off of other characteristics like genetics, disability, pregnancy, age. So Congress has the power to obviously legislate and expand civil rights protections to other types of characteristics. And just a fun fact, because I don't want this to be a really boring like history lesson, but the word sex originally was not in the original drafting of Title VII. This is a little bit of my home state, Virginia history. There is this legislator who, when this bill was, or not bill, but when this law was first introduced, I guess, as a bill, being more conservative leaning, he made a joke and he's like, we're going to have this law and like it's going to apply to all these minority groups, like women saying, you know, that their sex makes them a minority. And so his facetious comment ultimately ends up becoming law. And I always thought that was really interesting. So look that up because it's a true story. Anyway, so claims under Title VII cannot be brought against a specific individuals. Like you cannot sue your supervisor for violating Title VII. Instead, employers are subject to something called vicarious liability. So the person who does the wrongful act, whoever supervises them or employs them, I shouldn't say supervises, but whoever employs that individual is vicariously responsible for any sort of civil rights or tort or whatever wrongful conduct that's committed by that person. And so a lot of employers are subject to vicarious liability for violations caused by their managing employees. And so some of the lawsuits you'll see coming from Title VII will be for an adverse employment action. So I did not get this promotion because I'm Black. I was not hired because I am a woman. I was not, so that's an adverse employment action. Even if you have, like, for example, a position of leadership or a position that comes with prestige, and then you get demoted, obviously it's an adverse employment action. And then the second type of lawsuit that comes from Title VII is a hostile work environment. So if you work in a place that is severe and pervasive enough, like with sexual harassment, for example, in the context of LGBT people, if you have someone who purposely and maliciously misgenders you on purpose, it's not a mistake, but they get your pronouns wrong and they know they're wrong and they keep doing it as a way of taunting you. Recent case law has also said that that is considered hostile work environment. So I'm going to take a breath here and let Terrence jump in.
So thanks, Kylie. Especially looking at Title VII and how that applies to really what we're doing. Most of our work that we do is under the Kentucky Civil Rights Act, but also through our work share agreements with the EEOC, for example. We utilize Title VII for those employment cases that we have. So in Bostock, there's a court decision, Bostock, Kylie mentioned it earlier, she'll get back to it later in this presentation, but one of the things that was very important about that decision was it expanded the definition of sex and how that was applied in whatever work that how you were applying the law in a complaint or just whenever someone is suing or whatever under Title VII. And that was really important to us because prior to that decision, KCHR, since there was no explicit state protection, and I went through this with some of you last June, but there was no explicit protection in Kentucky. But with this Supreme Court decision, we were able to using our EEOC work share agreement through our processing of those complaints. We were able to apply that same rationale into our everyday work. And it also raised a question of Kentucky law and how Kentucky law was applied as well. And one of the things, I hate saying this publicly, but I will say it right now. But there was a question, we had talked a little bit about if we weren't doing it through the work share, if we were doing it specifically from KCRA, if we still went with it. And our statute in Kentucky is not as definitive as some other states would be. And so it leaves interpretation more open as opposed to being expressly prescriptive and limiting. So it in that interpretation to apply the law in accordance with the Supreme Court opinion, which is good, really good for us. I'm hoping none of them realize that and change it, because that's how things work. However, for our own work and looking at not just employment under the EEOC, what was really important was on, I think, January 21st of 2021, President Biden then had Executive Order 13988, which basically said the Title VII interpretation through Bostock was applicable across all the federal agencies when looking at sex. And so that expanded into our HUD work as well, so in housing. And they also offered guidance for us to take a look back to the year prior to see if there were any complaints filed that we previously could not have addressed, but now under that new interpretation and the executive order would be jurisdictional. And so they afforded us that opportunity to go back and contact people and say, hey, we may have said we can't do this. But now looking at this extension of the law and basically expanding or interpreting the Supreme Court decision on making it expand into other areas, you can now apply this way. And what's really important in how this works with us is every year, and I'm not sure if you all are familiar, but every year we have to sign our contracts with HUD and the EEOC. And in those contracts, we have to sign and agree that we are going to maintain a substantial equivalence, or our laws substantially equivalent to the federal law that we work under with the work share agreements. And so we review our law and also send them a copy of our law to make sure that we maintain our substantial equivalence in how we interpret and how we apply the law. And so looking at Title VII, for example, we submit our entire enabling statute really, and then certify that we are going to maintain that substantial equivalence in whatever we're doing. And so that's important to us because it allows us to, one, continue with that work share agreement, but also to work and address these issues statewide, especially for places that don't have a statewide fairness ordinance, which we'll get to. But that's, as great as that is, and as helpful as that is, we still have work to do, because one area it doesn't apply to is public accommodations, because there's no corresponding federal agency that would then apply this Title VII interpretation to public accommodations. And that's where these fairness laws and fairness ordinances come into play, because then those can be more expansive and for different localities to then work and say, okay, well, we want to do this. And so that's something that I'm hopeful for. We talked about it briefly in the past of something that we would push for in the future for the entire state instead of the localities that currently have them.
Thank you, Terrence. So talking more about the Kentucky Fairness Ordinances, Sorry, I thought I had to sneeze. Before the Supreme Court decided Bostick, 21 states had already acted on their own accord to extend employment discrimination protections to LGBT individuals. And since 1991, the Fairness Campaign has worked to get cities and counties all over the Commonwealth to pass anti-LGBT discrimination or like fairness ordinances. In 99, Louisville passed an ordinance protecting LGBT people from employment discrimination, but it only applied to the Louisville metro area and it did not include protections from housing and public accommodation discrimination. Also later that year, Lexington Fayette Urban County government, they have an ordinance that did in fact extend LGBT protections to include housing and public accommodations in addition to employment. And they also took an extra step to define gender identity to make sure that trans folks were covered, but provided religious exemption. And then in 2020, Woodford County passed the first countywide fairness ordinance in the state after 20 years had passed. So just some history about Kentucky specifically. Next slide. All right, and these are just the counties that to date have fairness ordinances. So if you see your county, shout out. I'm kidding, but. Okay, now the exciting part, at least for me, to talk a little bit about the law here. So Gerald Bostock, he was fired from his job as a county child welfare service coordinator after his employer found out he was gay. He expressed interest in participating in a gay softball league. So in May 2018, the 11th Circuit of Appeals refused to reconsider a 1979 decision wrongly excluding sexual orientation discrimination from coverage under Title VII. And so in this case, like many Supreme Court cases, I shouldn't say many, but like some Supreme Court cases, cases that present similar legal questions are consolidated and then packaged up neatly, and they go to the Supreme Court and they decide these important questions. And so in his case, in Gerald Bostock's case, the district court, which is the trial court, the lowest court on the federal system, they followed 11th Circuit precedent that Title VII does not protect LGBT people. I should say specifically does not protect people on the base from discrimination on the basis of sexual orientation. This case was appealed, and like I said, it was consolidated with another case from the Second Circuit with a similar holding. And then a case in our circuit, the Sixth Circuit, that held the opposite. And so what we call that in the legal field is it's called a circuit split. And those cases are like great candidates to go up to the Supreme Court. It's like, well, this area of the country said this, and this area of the country said that. Supreme Court, y'all figure it out. And so one of those cases is called Altitude Express Incorporated versus Zarda. In this case, Donald Zarda is a skydiving instructor who was fired from his job because of his sexual orientation. The federal trial court rejected his discrimination claim, saying Civil Rights Act doesn't protect against discrimination on the basis of sexual orientation. And so you don't have a claim here with the way the law currently exists. So in October 2014, Mr. Zarda dies unexpectedly, but his estate essentially sees the end to the litigation. His estate continues on his behalf. The other case, and I believe this comes from the Sixth Circuit, is about Amy Stevens. Amy Stevens is a funeral director. And when she informed the funeral home owner that she was a transgender woman and planned, essentially she comes to her boss and says, hey, I'm a transgender woman. And from here on out, I'm going to come to work like this, like how I look. The business owner fired her, saying it would be unacceptable for her to appear and behave as a woman. And so all these cases with different holdings go up to the Supreme Court, and in a 6-3 decision, Justice, I believe it was Gorsuch, wrote for the majority, which is a pretty big deal to be more of a conservative leading, well, I shouldn't say leading, he's a conservative justice. And they hold that discrimination on the basis of sexual orientation and gender identity was prohibited by Title VII. And here's the reasoning. So discrimination on the basis of either your sexual attraction or your gender identity is per se because of sex. So employers discriminating against a gay or transgender person, essentially what they're doing is they're accepting certain conduct in employees for one sex. For example, a man can be attracted to a woman, but a woman cannot be attracted to a woman. And so this conduct is only is acceptable for this group, but not that group. And so when you're treating different sexes differently, that is definitionally, this is discrimination on the basis of sex, because of sex. And so a lot of legal scholars say this is an example of progressive textualism, but that's essentially what the court comes up with. Next slide. So our takeaways. So not to turn this into a diversity training of any sort, but it's important to know that we live in a different time, and this is an important time. And we have to understand how we participate in maybe unconscious bias, or how we might participate in the further marginalization of LGBT individuals. And so what I want to start off by saying is that we should respect people's pronouns. And you see my pronouns are attached to my name in Zoom, but I go by she, her pronouns. I'm cisgender. And the reason why there seems to be now more recently this emphasis on pronouns is that as cis people, as cisgender people, we're privileged in the sense that we don't have to, I mean, prior to me even sharing my pronouns, I guess you all could perceive me to be a woman, whatever your perception was. This is to take the onus off of transgender individuals who may not have that same luxury, in fact. And so they don't choose, they just share their pronouns up front. And so to alleviate folks from feeling alienated or feeling singled out, we all just say, hey, my name is Kylie, she, her pronouns, and people can follow and do the same. So everyone feels included. We should avoid gendering people. What does that mean? So as an attorney, for example, when I talk to the judge, right, I'll say your honor. Honor is a gender neutral term. I could say Judge Ann Cheney. I wouldn't say your first name, but Judge Cheney, right? So Judge Cheney, I'm speaking to the person directly. So when we address groups of people, especially people we don't know, I don't know everyone on this call, and I don't know how everyone identifies. I would not say, hey guys, I would just say commissioners. It's a very inclusive term. And so it doesn't take a lot of effort. It's just using terminology and language that isn't gendered slanted, unless anyway. We don't want to put people in boxes. So you don't want to say things like, oh, tuxedos for men, dresses for women. People have genders, articles of clothing do not. So let people come as they are. And if you think that's just a matter of preference or opinion, there's been a lot of litigation that challenge like sex-specific or gender-specific dress codes in schools, for example. I come from Maryland, where there was a high school in Baltimore that required the students to wear white dresses, and it's an all-girls school. And there's really no reason why, other than the fact that, like, well, you're a girl, so you should wear a dress. And we live in 2022 now. Like, we're not forcing people to wear articles of clothing because of their gender. It's just, there's no reason, there's no reason for those policies. And then we want to avoid binary language. So you're at a barbecue, you're at your office, and you have a young female employee, and she says, oh, I just got back from vacation with my significant other. And you say, oh, and what's your boyfriend's name? It might be very innocent, and you may not have the intentions of making her feel any sort of way, but it is presumptuous, because if someone asked me that, I would say, oh, I've been with my girlfriend for 2 years. And so it's the same thing. You wouldn't want to assume someone's married and they're not. Just don't make assumptions, avoid binary language. You can say things like, oh, does your partner live here, Kylie? Or you can avoid binary language, because there's so many words in the English language you can use that doesn't single someone out. Because let's say my boss or my coworkers don't know that I'm a queer woman. I don't talk about my relationships at work. and you ask me, well, what's your boyfriend's name? I may not want to share that information with you, or it's just you're making an assumption about me. And we want to avoid assumptions at all costs. And so I know that seems like a lot, but it's very simple when you think about it. Next slide. Okay, so moving forward, be an ally and use your platform, especially in your positions of leadership, and really the watchdogs and the guardians of civil rights in the Commonwealth. Like, there is a higher expectation for the commissioners, I'm sure. And so your platform means a lot, and you are in spaces where you can influence and change the way people think about these issues and talk about these issues in a way that's going to result in a more inclusive state. In Kentucky, I think that's a really important thing. I think that educating ourselves about these issues to make our organizations more inclusive is really helpful. And I also want to say that, and this is probably the most important thing I want to emphasize, is that we all are going to make mistakes. I've probably made mistakes already, even just covering some of the subject matter, as far as coming from a space where, like, I'm not a transgender woman. And so I think the best person to give this presentation with respect to those issues is someone who would be directly impacted. But what's important is we shouldn't shy away from these issues because we're afraid of making mistakes or messing up, saying the wrong word or terminology, or using the wrong pronoun. People are patient, people are kind. And I think it's important to recognize that mistakes will be made, but it's just a continued learning thing. And you just continue to educate yourself and try to be better. Speak up when you hear things that are hateful, or you see discrimination happening. You don't necessarily have to call folks out, but call folks in and say, hey, what did you mean by that when you said that? Or, when you said this, it made me feel, or I have a niece and she identifies this way, and I'm sure if she heard that, there are so many ways you can be an upstander instead of a bystander. And I think that's important to empower each and every one of you to remember that. Respect people's experiences and how they identify themselves. You wouldn't want someone to say, well, Terrence, this was your experience and that's not how I see the world. Doesn't really matter. If you want to be in relationship and community with a person, everybody has experiences regardless of you're straight, you're gay, you're cisgender, you're transgender, and those experiences are valid. And there's just, and I don't know if anyone would agree with me, there's so much polarity and there's just so much strife. And we stopped having conversations with people. And so it's just really important to listen and employ empathy when you listen to people's experiences. I think it's important, to volunteer, donate, support, whatever, LGBT organizations, because I'm sorry, my cat wants to be in this presentation too. That's a way of showing support for sure. It's Pride Month, donating in someone's honor. My boss actually made a donation to an LGBT organization in my honor, which was really sweet. I mean, donate if you can, but volunteer, learn more about their work and the issues that they do. And lastly, have a conversation with someone about what you've learned today. I think that's important to take back knowledge that we receive in any space. We should be learning something new every day. And just talk to someone who may not be as well educated as you all are now on these issues, and just, educate others. So I'm going to take a pause here to get my cat to behave, but also to answer or try to answer any questions anyone has. And if you don't feel comfortable asking a question right now, because I always hated being put on the spot in law school, please feel free to email me. I genuinely mean that. Do not hesitate. Please do.
Thank you, Kylie. Does anyone have any question or anything they want to ask? And definitely want to give, a round of applause and thank you and all of that. But I did want to make sure we had space if anyone had something they wanted to cover now, or if they want to email, if you didn't catch it, I can give you her contact information, so you can reach out separately if you would like. All right, I don't see anything popping up in the chat, but thank you, Kylie. And you're more than welcome to stay. It's not very exciting, but if you want to, have at it, or you can go tend to the cat.
Yeah, no, I have some other work I have to do, but it was so nice. Thank you, everyone. Thank you, commissioners, for sharing space with me this morning and for your time and attention. I know you really care about these issues, and I feel very comfortable that you all are in the positions that you are in. Please reach out to me if you need anything. I hope you get the AC fixed, Terrence, and I hope everyone has a good day. Bye, everyone.
Thank you, Kylie.
See you later.
So I did want to run through a couple other things really briefly before we move on. And then if you all have questions for me, but we have done a couple things lately to try to help the commission, I guess. One of the things that I didn't know was going to happen, but over this past month, I worked with HUD to identify possible money that we may have left on the table. We know that money is very important right now, and we definitely need it, especially in looking at some of the other items that were in my report. But one thing that we were able to do is I talked to HUD about, in our cases, we have post-cause activity. So anything that happens with HUD cases after there's been a probable cause determination, if there's a documented triggering event like a scheduled hearing or something after cause has been determined, that's a triggering event for supplemental payment for cases that we've worked on. And it came when I was going through HIMSS, the HUD management software. I realized that there were some cases that we did work on that the triggering event wasn't uploaded into HIMSS, but I was very thankful that Colt had, when he was working on some of these cases, in our legal software that we purchased last year, he was uploading all of that information on his end. And so it was very helpful being able to go back to any case that we did from the time that we put in the legal software, the legal case management software. I was able to go through, and I made Joe help me go through every single case in there and see if there was a triggering event that had occurred that hadn't been also transferred over to the HUD side. And so I'm not certain of the amount that we might have sent over or added to our payments, but it was significant in that we had, and you can correct me, I think there were 31 or so that we looked at, Joe. But quite a few of them had triggering events that were then added. And so I'll get a number when our HUD person comes back from vacation on exactly how much that would go into being provided for us for work that we've completed. Unfortunately, those things weren't documented before we got the case management software. So I was only able to go back until the year that I started and when Colt started, but we will get a decent amount in that. So that's something I wanted to update you all on. As far as other finances, things go, Joe, myself, and Kylie, our legal intern for the summer, had a conversation with the governor's office, the general counsel, last week on looking more into the community foundation and fundraising model, just to see what other questions they had on permissibility and to see if that's still something that we can consider. We are supposed to get some type of information back in the next few weeks about what they thought after they again reviewed the policy that we walked through before, and it was a good conversation. Joe might touch on it again in his report, but it was a good conversation. I felt optimistic after being able to actually talk more about the structure, that it does seem like something that should be able to fit. So that's something that I'm very excited about. Hopefully we can do that. And then more on HUD type things. Next year, this is something else that would be helpful for us. There will be a 6.5% increase in case payments through HUD. So whatever our contract happens to be next year, the payment for that work will be, it's 6.5% each case. So anything that we do, it will be a little bit more. It averaged out to be $200 to $400 more per case, which over, collectively, that's helpful. And then there is no change in the supplemental payments. However, that's something that they'll look at next summer as increasing that amount as well. There's also another allotment of funding that they're going to have next year that I've already put in our intention to reach out for it. It's specifically geared towards things that address covering, like, if there are gaps in funding or whatever, if there's something technology wise that might be helpful in making the work happen, even if we have fewer people, especially as people work more from home or just technology challenges, they are allocating a little bit of money for people to apply for technology supplements. And so we discussed a possible plan to apply for that as soon as it's made available. That could be ideally a better scanning system, so then we could have all case files completely scanned in and ready for digital access. So if we are disrupted in building, you have full access to all case files, or that's the hope, is something like that. I looked at that last summer and the cost of those scanners was mind-blowing. So that's just one of many options that we'll discuss with HUD, but I just wanted to let you all know that that was the direction we were going. I think that's all. That if there's any questions from what was in my report, or any questions now? Sure, Commissioner Cheney.
So the first thing I would say is that everybody is working incredibly hard across the board. In looking at the material for this month, one of the things that I noted is that, and again, everybody's working incredibly hard, but we're sort of static on the age of our cases. We inherited an incredible backlog of cases, and everybody is trying so hard to work through that, but getting through that volume is impeding our ability on new cases. I mean, it's like an immovable mountain. Is it possible to employ, subcontract attorneys, or what things can we do if we have additional revenue to try and chip away at the case volume?
So that's
They can work any harder than they are.
right.
Yeah.
It's a really good point and a great question. That's something that I've asked to a couple things on that. One of those, at least for housing, one of those, granted, we don't have as large of a backup in housing, but one of those parts of that grant or the funding to cover some of the technology things, part-time or contract work was tentatively approved to be, that money be used for that as well. So that's one consideration that would just have to go towards housing cases. And there's also one barrier we have is hiring part-time isn't really something that we can do, but we can do some type of contractor work. It's a little bit harder on the investigation side and that's where we really need the help, because there has to be training and all of that. So still going to try to figure out how we can make that work. And another thing that we're trying to do, especially looking at that, and it's really difficult right now with the closing of contracts, but also trying to make sure we're moving ahead and the new things coming in. But we've been trying to look at the cases that may be aged a little bit more and having even more intentional reviews to bring them to panel to have conversations about where we are at a decision point on these cases that may then lessen the age because we're getting rid of some of them, or we're getting to a question that might prove to be dispositive of whatever we need to know in that investigation. It's really difficult and challenging on them because they have a lot, and we have lost investigators. So that makes it even harder. And so I'm very grateful for the work they've been able to maintain in that period as we lose people. Some of them just had a bunch transferred over to them because Andrew is taking over on housing, replacing Claudia. And so what Andrew had is being shifted to the other investigators while they already have their other things going on. And so it's all something that we're really trying to work through. But as far as that, go ahead.
What can we as commissioners do to support you? And I asked that question hoping for very specific responses. What can we do to support the reduction in the age of cases?
The most specific I can think of is as we move through this summer and the fall, it would be very helpful in getting. I talked to one of the senators about how we could ways to hopefully grow our budget. And one thing that was recommended was building friends and allies right now, so that when we get to that point of budgeting and all those conversations, that we have a lot of friends. I worked with a lot of legislators on budget, and ultimately some of the ones in leadership changed some of that work later on. But having those allyships early, reaching out to people in the legislature, maybe letters, and as we get to the interim period, having those conversations about why we need funding would be important. And the reason I say that is because we just need more people. There's so much that we ask of everyone, and the investigators, especially, to cover a whole state with so few people. And we can't. One thing that's been challenging, as you've noticed, some of those positions have been open, and the challenge is, one, there are people that are leaving because they can get more elsewhere. And then I've had so many conversations with people to do some of these positions. And gas is like $5.15. Given the cost of living, some people, we can't afford people. We've had conversations or interviews and all of that. And once there have been some really good candidates, and then when it comes down to it, they're like, oh, I can't do it for that though. And so it's really, really challenging in looking at where we are financially. And also making sure we're not doing, I'm very appreciative of all the work that the team has been doing to try to address these cases. And I think I'm very proud that the age isn't going up. It's plateauing, but it's not going up. And that shows how much work they are doing. And so I do think that they should be commended for that. And I really just want to find ways to get more people in to lessen that.
And I just want to be very clear that this is everyone on staff is running at 150 miles per hour. And I appreciate that. What I'm hearing, Terrence, is that this is a personnel issue, a staffing volume issue. And are you comfortable that it's not that we can't gain any more efficiencies with internal processes? There are no other things to be done other than we need more people.
There are some things that can be done and that are being done, but we can't really go full bore into them until after this contract period, because right now they're really working hard to make sure that we get through the cases that we need to. We do have some, and so there are some other efficiency things that we're working through that can help, but it really is largely a numbers issue. And so as numbers change, so do the processes for efficiency, because what works with 5 investigators is a little harder with 3. So shifting that and reviewing that, as well as trying to get more people in, thinking through the ideal person that could come in and help with case processing, investigating, and management. And thinking, is that one person, or is that filling the supervisor and investigator role, or is it? So trying to work through that and what works best with the current team is all something that we're looking at. But as far as overall processes, that's something that we can't tinker too much with. I don't want to be, we can't overload and say, okay, we're doing all of this different right now, and you have 45 cases that you have to work on and change how you're doing all of them. So it's more of a as new things come approach, and then shifting more once we're able to address kind of where we are.
Thank you.
Any other questions for Terrence from anybody? And does that conclude your report, Terrence?
One question, if I could.
Okay, Rabbi Libman.
This references something we were discussing earlier, but it's on my mind. As long as I've been on this board, we've been talking about moving. This is going back to the issues with the offices. Is there anything that is changing on that in the foreseeable future?
So we went through the moving process, and the only building that came up as an option, because the state is there's a long process. The only building that came up that was a possibility has similar management issues to this building. It's right down the street. The cost to move to most likely not get out of some of the same issues did not make sense, and that most of the team here didn't want to move anyway if we had these conditions that were met on staying where we were. We had partial tentative agreements on some improvements of the building. We worked through real property with the state. We worked with the owner of the building, and then unbeknownst to us, the building ownership changed overnight through a foreclosure. And so all those conversations and the work plans with the state that we did a few months ago to make these improvements, get new air units, get a consolidated and new remodeled floor, all of those things got kind of put in limbo as the ownership changes hands and all of that. And so in that period, that's also when the air goes out. And so now we're going to submit a letter for an emergency for provisions to.
Understood. Thank you for explaining.
Any other questions for Terrence? Any other items on your executive director's report, Terrence?
No other items that, unless anyone has questions about something written or presented.
Okay. Let's move on to budget and personnel, Brandon.
You have my report before you. I will say that it looks like we're going to finish the fiscal year with a $20,000 surplus. And depending on how some things shake out with the building and the payments to the new ownership. So are there any questions at this time? And I will add one thing about personnel. The personnel cabinet is doing a salary study that is due to the legislature on July the 7th. And I haven't discussed this with Terrence yet, but I had some ideas that I think our enforcement staff are undergraded as far as pay grade goes. So I think we should probably reach out to them and look at pay grade increases to the job ID for the investigators.
So if personnel is doing that and the date for the submittal is July the 7th, what information do they send out to the agencies in preparation for that? And when did they send it out?
They aren't sending it. They're just doing it on their own. They're not sending us anything. But I think if we reach out to them and have them look at the classification for the enforcement officers, that could help, because after going through the hiring process recently, it's difficult in this market to fill those positions.
Sounds like a good idea to me.
Yeah, and I'll get with Terrence today and we'll work on that. I have meant to mention it to him in the past, but I've had a lot of things going on. So with the fiscal year end, this is the busy time of year for the accounting department.
I guess any questions from any commissioners? It was good to hear that we're going to be operate at the end of the year with an operating surplus of the $20,000. And looking at the budget items, I guess some line items that I had some questions, or at least needed to know more about. So E147 is, what advertising services are we using?
Those are specifically set aside for the partnership grant with HUD, and it was fair housing advertising. We ran ads in the Courier Journal and the Herald Leader.
And I think those are, and a couple other line items are like that. Those are, it's interesting when you look at it, because those aren't things that were coming out of our budget per se. They're through the grants that we get, and then we get those funds from HUD and then pay them out, but they're given for that particular purpose. So it's not that we're spending on those things. It's just that those are what those specific grants covered.
Okay.
I think, yeah.
What about E175, other non-professional services?
That was also partnership money, and it was for event planning. For the, is it a housing? I don't know. How did you describe it?
So it's the same grant there was planning for a fair housing event that is being transitioned to putting together a fair housing book. And so those are also those same funds, that 13,000 that we get a year to do work like that.
Basically found money. So
Okay. What about I think it's 212, which is electricity. Just looking at that, if we're really not using the building, we're in the building, but at least our costs seem to be going up.
So that is that's a fixed rate, and it's probably due, the reason it's not reflecting the 2022 totals is because the finance cabinet had us stop paying it. Hold on just a second. Let me look at the difference. Yeah, it's we're a little bit actually below where we were this time last year because the finance cabinet had us suspend payments due to the new ownership.
Okay. And then E802, which is the Commonwealth Office technology charges.
Mhm.
Is that new equipment?
No, that's services for the email accounts. There was also, I looked at this because it differs from month to month. And there are quarterly charges for a security assessment and also something called an ENT assessment. And I reached out to COT to try to figure out what an ENT assessment is, and they have not gotten back with me yet. So I'll have to, I've got a contact there that I don't know that it's anything we could do anything about, but I'm not sure what ENT stands for, but other than ear, nose, and throat, but it's some type of quarterly assessment.
Okay. Well, those are all specific budget questions, but let me just back to something when Terrence was talking about HUD and responding to Commissioner Cheney's question. I guess I try to understand the contract periods for HUD and EELC. And I get a report or 1 month and it says we met our contract terms. We submitted it. When I see that, I operate on the assumption that we fulfill what the contract terms are. Then I get to a meeting and it's saying, we still have, we're in a big pinch to in fact meet the contract terms. This is not really for you, Brandon, as much as it is for Terrence, in terms of what those contract periods are and when we say we met them, what are we meeting? And if we met them, why we're saying we need to all of a sudden do a big push to in fact meet it. It's confusing.
It is very confusing.
It is.
HUD, they have separate contract periods. So we're working under we're technically working under basically 3 fiscal years because we have ours, we have EEOCs, and we have HUDs. And the HUD contract period ends July 30th. Our actual work, it's all confusing. The work to be completed has to be done before June 30th. Then there's a period in July where it's the reconciliation period that's post contract performance, but it's for review and going back and assessing some things. An example is if there are cases missing documentation, the work had to have been completed by June 30th. The ending year is July 30th. So that's the HUD one. And what's confusing about that is we have 3 levels of review with HUD. And so we're currently going through this right now. This year we have a set number of cases that need to be completed by June 30th. Same with the money that's been expended out for those different expenses has to be done by June 30th. So we had 2 levels in HUD review the casework and say, okay, these are all approved, contract met. However, there is a top line reviewer that can go back and change it and request more information or flat out reject it and say, no, this can't be addressed in a reconciliation period before July 30th. So this has to go back or this doesn't count. That's HUD. It's very confusing. It doesn't make sense to me, but that's how they do their process. EEOC is a little more straightforward. We have until the end of September to get our cases, the number of cases to be processed met. And at the conclusion of that, that's once they've been closed, that's when we've met the contract. We've looked at it based on the pace or trajectory to see, okay, well, we need this many more this month, that month, or whatever to make sure that we meet the contract. But EEOC is also interesting in the sense that once there's a benchmark date, that if you have exceeded a certain amount by the benchmark date, you get to draw down, what is it? Is it 60%, Brandon?
I'm not sure on the percentage. It's a portion. Yeah.
So if it shows based on your work that you're already, like you're on pace to meet that number, you get to draw down a percentage of it early for that work that you completed, but it doesn't necessarily end the contract year until that September. That's actually, we haven't had a conversation yet about this, but we just were made aware that that is actually changing for next year for EEOC. And that's something that we'll have to discuss on meeting structure and all that based on the way that we do cases, because the EEOC will need to be completed early in September instead of at the end. But right now it's September 30th when we need to have all of those items completed for the EEOC contract. And so it's a little confusing that we're operating under 3 different fiscal years. And the most confusing is that HUD can unilaterally decide that they're changing what that entails up until the end of the reconciliation period.
Well, I guess what I would say is then you all need to report it to the commission like that, as opposed to saying, well, we met the contract terms and then we come back and we find something else. So I think you need to break it out in more definitive, like you just got through explaining. So in fact, we can in fact track it, because right now it's not that clear. Okay, anybody else, any other questions on budget and personnel?
I will also add that EEOC is actually increasing the payment amount for resolutions from $800 to $830. So, that's also another $5,000 to $6,000 increase from our federal funds that will be helpful. It's about 3.5%, but it's something. So
right. Any other questions, budget or personnel? Okay, let's go on to the enforcement unit. Is Cynthia going to give that report?
We are presenting 29 cases to the commission today, 1 administrative closure, 24 NPC recommendations, and 4 withdrawals without settlement.
Okay, and because we don't have a quorum, we can't approve or accept those. I guess would say if any commissioner has any questions about any of those cases today, you can raise those questions at this time. I guess the only comment I would make is that as I look through some of the cases in terms of no probable cause or dismissal, when I do read the write-up, it's not always clear to me that something is a dismissal versus a no probable cause. And so I guess you just need to look at the language. The Finch versus Orangeboro, Smith versus Centerstone, Moran versus Louisville City FC are just three of the ones that I did. But just check that language on it in terms of, but we won't be able to take any formal action with it because we don't have a quorum. We only have 5 commissioners on this today. But if any of you have any questions about any of those cases, Commissioner Cheney.
Chair Burse, I did, but I will hold those for the moment. I think if I'm not mistaken, we do not meet next month.
You're correct.
Typically.
Correct.
So I guess my question is more around to prevent further delays. Will we be scheduling another meeting this month so that we can go ahead and take action on these, or?
I guess the question is, do we, in order to meet the contractual terms for the contract, for those that have June 30 deadline, I guess June 30 on it, which is next week, do we need some official approval from the commission in order for you all to submit those, Terrence?
We do not. We just need for us to submit these, for example, for EEOC, we just need to have letters sent saying what way the case went. So we can still sign those without having an adoption in a meeting. The housing cases, for example, once they have been once that determination was made, once I go into the HIMSS system and mark the date that that the parties were notified that a determination had been made, and that's when HUD considers that matter closed. And so that's how we would close them regardless. So as far as meeting contracts, we can still close these without having a special meeting to send them out.
Okay. So I guess, given what you said, there's no need for a special meeting prior to our next meeting, which will be in August. Okay. Which gets us to the education and outreach. Is Marianne going to give that report?
I am, as soon as I can click my video. Good morning, everyone. You have the education and outreach report, which entails the activities our staff has been participating in over the last month. I would just like to very, very briefly highlight the Race for Justice that occurred last Saturday. That was an extremely successful event. It was sponsored by the Future Ancestors, and some of those students were with us at our last commission meeting. It was an opportunity for families, teams of folks, individuals to get out and run, walk, or crawl. Many folks attempted to take 26 laps around a track over at the Norton Sports Clinic, where we had an event earlier this week, yesterday actually. The goal of running or walking 26 laps was to do 1 lap for every year of Breonna Taylor's life. And her mother and family were there at the event, and they got to walk around and see some of our tables. We had a very nice table set up. We gave out a lot of bags and a lot of little coins that have the Kentucky Commission on Human Rights on them. I tried to make sure everybody who went around the track got one. So that was a really nice event. Our director ran. He still to this day won't tell us exactly how many laps he did, but he did a lot more than the average Joe on the track. So it was really cool to be able to look up and see him on the big screen and tell everybody, yeah, that's our guy. So that was our highlight for this past weekend. And of course, we attended the workshop yesterday at the Urban League at Norton Sports Facility and had a very, very informative session on housing and the work that the urban leagues are doing across the country, particularly in the Carolinas and in Oregon. So with that said, that is the conclusion of my report, unless you guys have some questions. Great, thank you.
Anyone? Okay, I don't see anybody raise their hand. Then let's move on to the legal unit report, Joe.
Good morning, everyone. Yeah, so you have my reports. We have some updates to the updates to give you. Yesterday, we were able to settle the case of 9111E, Gregory versus E&E Brokerage. Staff Attorney Colt Sells handled the mediation very well and reached an outcome that we think is very positive considering the facts. That is still tentative. We don't have a check yet or a finalized agreement, but we have a commitment by both parties that they will settle it. So that case is going to come off the report next month. We did PC a new case, Jones versus Bradford Heights. That charge has been filed, and so we're going to move forward. That's a housing case we think is a relatively strong. And then we have some additional movement. We've got mediation coming up very shortly in a case called Brown versus Madisonville Housing. We have some other housing cases that have been sitting on our docket for a while, but we've got those assigned and we're trying to move those forward. Those are all in various circuits around the state. A couple of appeals. We are a party to the case of McKenzie. That case is on appeal. We've filed multiple dispositive motions, and the Kentucky Court of Appeals has decided to pass those motions to the merits panel. So we're going to have to actually brief the case in our attempt to get it dismissed. We think there's a lack of jurisdiction in this case, and it should be pretty simple, but we'll see how the court does. Teen Challenge is now officially off our books. We have re-entered the original NPC order consistent with the Court of Appeals order in that case. Let's see, we've got a couple of the pre-charge activities category is kind of vague, of course, because of the statute. But those are cases that I inherited from predecessors that have been sitting for a long time. We should not be adding any new cases to this category. Mostly it's just a process of getting them off our list. And we have reduced that number by 2. So we are making some progress. One thing to note in the civil actions, which the commission has an interest, that's kind of a new category that I wanted to be more specific on. Those are cases where we are a party, but not the or we have an interest, but we're not the key party. Joyce Turner versus Norton Healthcare, I want to mention, I talked about that last commission meeting. That case is in the Kentucky Supreme Court. We are filing an amicus brief in support of the plaintiff's argument about how the KCRA should be interpreted consistent with the ADA. That brief is nearly complete. We had an initial filing date of early July. That's going to get bumped because the appellant has requested a 60-day extension to file their brief. We had a meeting with the appellant counsel, a very productive meeting where we talked about the case, talked about strategy. Once our brief is complete, we'll both, of course, submit it to the court and submit it to you all to see the kind of work that we're doing to help interpret the KCRA in a way that benefits the interests of all Kentuckians in having their rights protected. That case is specifically a disability claim. We've also very recently identified another case, this one in the Court of Appeals, that involves a disability and age discrimination case coming out of the Bullitt Circuit Court. And we are meeting with plaintiff's counsel in that case, and we will likely file an amicus brief, and that will be due at the beginning of August. So that's just in the initial stages, and that will show up on our next report, of course. But the amicus practice here, or amicus, depending on your pronunciation, is starting to pick up a little bit of steam. And I think the commission can play a really positive role. One thing that clued me into the court's interest in our participation is I was watching oral argument from a case a couple of years ago called Barnett that dealt with disability discrimination. And Chief Justice Minton of the Supreme Court specifically asked plaintiff's counsel, what's the commission's position on this? Have they dealt with cases similar to this? And of course, plaintiff's counsel had no idea and couldn't answer. But that is a case that, of course, I wasn't here. But these cases that deal with the KCRA's interpretation are really important, not just to the work we do internally, but of course to all parties who bring claims under the KCRA. And the courts appear to be seeking our guidance, and so we're going to try to step into that role and play an active part in the interpretation of the KCRA in a way that benefits, that expands the rights, or at least gets the courts to interpret the rights consistently in a way that benefits Kentuckians and protects them from unlawful discrimination. So that's where we are on that. We have a couple judgments that we're still trying to seek. We have already filed in circuit court motions for specific orders giving us the authority to collect judgments, and so that's in the works. And kudos to Colt Sells for moving a lot of these cases forward and being very diligent. You'll notice in the case. Go ahead, please. Do you have a question, Chair Burse?
No, it wasn't me.
Oh, I'm sorry. Okay. And I just wanted to clarify that notice that we just settled the Gregory case. This case is relatively recent. It was PC'd by our unit in late 2021, and it's being resolved in just 6 months. So we are moving things very quickly. And of course, we're subject to respondents counsel and subject to the schedules of hearing officers. But nevertheless, we are being aggressive in getting these cases moved and to positive outcomes for our claimants. So that's my report. If you have any specific questions, I'd love to try to answer them.
Any questions from any of the commissioners? Okay, well, thank you for that.
Thank you.
Okay, move on. Any committee reports?
There are no committee reports, just reiterating that we did reach back out on getting some guidance or clarification on the possibility for the fundraising.
Yeah. Then let's move on to new business on the agenda. Is there any new business any commissioner has? I have a couple items I want to bring up. Okay. I think as we've I guess really this morning and really in previous meetings, as we've talked about the work of the commission in terms of where we are, the volume of work that's there, a number of things, is my thinking, and would like to get commissioner's reaction, is that I think that we need as a commission a sort of a day-long session to really do some strategic planning in terms of really discussing what is in the statute, what are the statutory authority for the commission, things we're working on, and begin to talk about how we either change processes or modify processes to become more efficient while being true to the what the commission was founded for. So I'm thinking that a full day strategic planning session, and I use the word strategic planning, it may be more than just strategic planning, but just in terms of one, helping all the commissioners to understand the process and what the staff is working through, to hear from the staff in terms of how their things are working for them, and are there some changes or in terms of processes that need to be made to be done. Talking about Terrence interfaces with legislators all the time in terms of what's going on, and I think there's a role for commissioners to play in that. And I think that the role of commissioner is in terms of where the commissioners want the commission to go from a strategic direction as it relates to further broadening the authority of the body, or more enabling legislations to do more and whatever. Joe is new on board. I think he has some ideas in terms of things. It's just to hear from him. So what I'm thinking is, we're after today's meeting, we're not scheduled to get back together until the third week in August. In this interim period, finding a day when we as a group can spend it together, and maybe finding a facilitator to help us work through this process in terms of where we are. Being interesting to hear what your commissioners' thoughts or responses to that are. So it's a bad idea then.
Oh, I think it's a good idea. I think it would give us more insights into a lot of the stuff that is being done that we don't really have hands-on knowledge of. So that would give us more information to work with. Who knows? We might come up with more ideas to do better things with what we've got. So I think it's a good idea.
Some new tests for deciding whether
I'm wholeheartedly in favor.
Okay, so we'll, Terrence and I over the next week or so, we'll work on that and see what we can come up with, put together a potential schedule and agenda, and see what we can kind of send something out that you all can look at and review around. But I think it would be good for us at this juncture to really do that in terms of, I'm not certain when the last strategic planning session for the commission was done and where it is, but I think it would be very helpful. So that's number one. The second one is, and I've already talked to Terrence about this, is I think that he is entitled from us a performance evaluation on an annual basis. He's now been in this job more than 2 years. I think he's got some anecdotal feedback, but I think that he is entitled to some feedback from the commission itself. And so I will be working on an instrument or something that we can use that I will circulate to the commissioners in terms of what your input, what you think about, share it with Terrence to see what he thinks about it, and then come up with something that's final. But I think that, the rest of the staff gets evaluated as part of the state personnel system in terms of where it is. And I think he's entitled to an evaluation from this commissioner, so he knows where he is and what the performance is. So I think that the performance evaluation document, along with a strategic session, will be very beneficial to our future direction. So I will be doing that. Any questions or comments from any of the commissioners as it relates to those two items or the last item? Okay, and then again, our next full meeting or scheduled meeting is August the 18th, and sometime between now and then we find a date that we can get the majority of the commissioners there. We'll set up for that day-long session, and we'll try to do it in person somewhere where we can all be together and also be able to meet safely in terms of where we are to do that. So, okay. Any other matter or announcement that anyone has would like to bring up at this point in time? Okay. Hearing none and without objection, we'll let the meeting is adjourned. Thank you all, commissioners, for being there. Thank you, staff, for the reports. Thank you for the exchange. Very, very beneficial in terms of where we are. We're an organization that has a big commitment in this state in terms of where it is and what's going on. And, we just need to keep working and chipping away at it. So thank you all again for your time and for your commitment to helping to make Kentucky a better state.
Just to regulate carry.
See?